and some went through productions. That's at 6 of the redacted appendix, 3493 to 3393 to 3494. Again, she thought of these corporations as things that did things for Michael. She was not looking to them for protection. And notably, there's no testimony from Mrs. Robson saying that she looked to these companies or any individual associated with them for protection from Jackson. Her deposition was taken for 7 hours. She was represented by my friends on the other side. This issue came up on 2 different summary judgment motions. And you know how many declarations they put in from her on this issue or any other issue? 0. Upkiss. None. The reason they didn't put it in is because they couldn't put it in. Now contrast this with the situation with the church or school. The paradigm special relationship in this area. A child comes into contact with an abusive priest or an abusive teacher because of the fact that they're employed by the church or school. So it's reasonable that a parent would look to the church or school for protection against these people who the church and school are vouching for. That's not the case here. The Robsons came into contact with the corporations only after they formed a friendship with Michael Jackson. And we're not looking to Michael Jackson's for companies for protection from Michael Jackson. And again, I sound like a broken record, but there's no evidence. This is summary judgment, not demur, that they did. The evidence and the record is to the contrary, as the cited testimony from Mrs. Robson shows. Now, getting more specifically into the special relationship, this court lists, I think, 5 factors, pages 20 to 21, as to why it finds a special relationship. First of all, 2 of them, at least as to Robson, are contrary to the evidence. Okay, the court says that employees assured the parents that they would be well taken care of. That's wrong, as to Robson. There's no evidence of it, not supported by a shred of evidence as it relates to Mrs. Robson. None. She testified for 7 hours. I just said it all. She never put in a declaration about this. This is just made up, okay? You're treating an allegation in a brief as evidence. And I would refer to pages 47 and 48 of our brief in the Robson matter, which goes through this and explains in depth that there's no evidence of this. All she could have said is, hey, I looked to these or someone from the corporations assured me they would be safe with Michael. She never said that. And I'll tell you why she didn't say it. It never happened. Again, this is summary judgment. 2 very good judges looked at this and said there was no evidence. Okay, the court also says there was a special relationship because molestation occurred in a, quote, recording studio that was run and staffed by the corporation's employees. Just wrong. Again, there's no evidence of this at all. Robson does assert he was molested in a recording studio called Record One. There's no evidence that Record One was owned or run and staffed by the corporations. It's no surprise. It wasn't. Record One is an independent record studio in the Valley. Okay? Michael sometimes recorded in that record studio, as did tons of other artists, but it was not staffed by these corporations. It was not owned by these corporations. It had its own staff. Again, the tentative is taking assertions in a brief as evidence on summary judgment. 2 different judges grappled with these records for years. And they looked at the records. They didn't just accept assertions from a complaint as evidence. So let's look at the other factors. And I'm keeping a watch on my time. But the tentative says that Robson was a young child, of course he was, who is by definition vulnerable and dependent on adults who take care of him and supervise him. And that Robson was in the care or supervision of the corporation's employees, including at locations staffed by those employees. Well, the contention that Robson was in the corporation's custody, something that, again, both Judge Young and Judge Beckloff on separate occasions rejected based on the evidence, not allegations, but saying that they were in his custody because a housekeeper cleaned up Jackson's room and that drivers drove Robson and his family is a stretch too far. And the court's decision here is clearly contrary to the 4th District's decision in Eric J. versus Betty M. 76 Cal App 4715, which we cited repeatedly in our briefs, as did, and I sound like a broken record, the 2 different trial judges in their rulings. Yet this tentative doesn't even grapple with it. The only special relationship cases this tentative talks about are non-child molestation cases. And by that case, and I just want to talk about that case because it's pretty, it's pretty out there as far as what they hold. In that case, a man was a convicted serial child molester. Michael was never convicted of anything, by the way. His parents were specifically told, this man's parents were told by his parole officer that he would likely molest again. The man then shows up at his parents' house with his new girlfriend and her young son, and they stay overnight on several occasions. And the parents never warned the woman about the risk of molestation of her son. Okay, and of course, we know what's happened. The child was molested in the parents' house. Okay? The Fourth District says there's no duty to report or warn because there's no special relationship, despite the fact that the child was staying at the house of the parents with every reason to believe the child will be molested. This is a case that has, again, been cited repeatedly by us in the trial courts below, and I think it needs to be grappled with. Turning to the issue of employment, which is the final